Let's talk about the story of Mrs. Donahue, probably the most famous woman in all of the common law. So, about 100 years ago, Mrs. Donahue left her home in Scotland to go and meet a friend in a nearby local cafe. The friend had invited Mrs. Donahue, which becomes important later in this story because the friend paid. It was just a cafe, it wasn't a posh restaurant. So Mrs. Donahue ordered a pear, the fruit, a pear, and a drink called a ginger beer. Ginger beer isn't alcoholic, it's what we call a soft drink. It's just like Pepsi. You probably wouldn't like it. It's a fizzy English drink with ginger in it, and that's what she ordered. And it came in a brown glass bottle. So Mrs. Donahue talked to her friend, she ate her pear, um, and she slowly poured her ginger beer out into a glass and drank it bit by bit. And then this bit, she got to the bottom of the bottle. I'm saying a lot in this story because everything about it displeases me. She got to the bottom of her glass of ginger beer and out came something disgusting, the decomposing body of a large snail. She claims that the next day she was very ill and also that she suffered shock. Remember, it's 100 years ago. People were maybe a lot more easily shocked than they are now. And she tried to bring a legal claim against the owner of the cafe, Mr. Mincella. Sounds like it was an Italian family cafe. So good luck, Mrs. Donahue, with that. And actually, she didn't get very far. If you know contract law, you know that you have to be party to a contract to make a claim under that contract. Mrs. Donahue was a third party because she didn't pay. The contract is between her friend and the cafe owner, Mr. Mincella. Now remember, it's 100 years ago. Consumer law for the public was not what it is now, and she felt there was nothing much she could do. But she found a young Scottish lawyer, Mr. Walter Leachman, also very famous in the common law, and he went to court and said, look, even where there's no crime and no contract, there absolutely should be liability in cases like this. So he went to court with that argument, and this was the first recorded case of negligence in the British legal system. The judge in this case, Lord Atkin, in the very highest court, said there is a thing called a neighbour principle, that even when there's no crime and there's no contractual relationship, people have to be careful in certain circumstances not to harm one another. And if they do, they have to pay compensation. So Mrs. Donahue has become famous in English legal history, the lady who got the snail in the bottle, because her case, led by solicitor Walter Leachman, was the establishment of the law on negligence. And if you think about it now, in the USA and the UK, people go people go to court all the time, on the basis of you were negligent, you weren't careful enough, and that caused me harm. So we've got medical negligence. I haven't been drinking ginger beer, I promise. I'm just on a very windy hilltop. Medical negligence, dentists' negligence, lawyers' negligence. They're all types of professional negligence. But if you are just not careful when you're riding your bike and you hit a pedestrian, or you're just not careful if you're a theatre and you sit someone too close to the orchestra and they say, your negligence has affected my ears. It's really big in our system now, but it all started with Mrs. Donahue meeting her friend for a pear and a bottle of ginger beer. See you next time.